Here's a segment from a recent Gun Talk radio episode. You can listen to all the Gun Talk radio podcasts however you tune in, or check out guntalk.com for more.
People.
Well, the warmest hello that I can offer. I'm Tom Gresham. This is Gun Talk. It has been a wonderful week. It has been a glorious week. It has been monumental. A landmark decision coming out of the United States Supreme Court. We thought it was going to be good. I had hoped it would be good. Never in my wildest dreams did I dare to think that we would get it as good as we got it. Frankly, it's more than most people understand at this point. And we're going to be spending 3 hours talking about it. And it doesn't mean we're going to not be able to talk about the giz-whizzes and the doodads and the guns and the ammo and all that. We'll do a little bit of that. But frankly, as soon as this decision came out on Thursday, we went to work. We contacted everybody that was scheduled to be on the show, all the guests, and said, look, we're going to put you off. We're getting a whole new group of guests. We're doing nothing but talking about this monumental decision, which is simply going to change the way gun control laws are viewed, and frankly, which ones are allowed to stand in the United States. It is whatever you have been told, I think, whatever you have been told about what happened on Thursday, and a lot of the media coverage was about the New York concealed carry permit scheme, and it was ostensibly about that. But honestly, that was kind of the smaller, as good as it was, that was kind of the smaller part. Because what we were given, a birthday gift given to us by Justice Clarence Thomas on his birthday, is so much more. And now we're still unwrapping this present to find out what's in it. And it will be a process of years to figure out what we can do with this thing. But honestly, I think we've been given an entire truckload of snap-on tools with which we can disassemble a lot of the gun control laws in the country. Joining me to talk about this and explain what it means is law professor, Second Amendment attorney, and all-around good guy, Don Kilmer, joins us right now. Happy Bruen Decision Day.
Well, happy days to you too.
You've been a little bit of a busy guy, haven't you, since Thursday?
I have been, and everybody wants to know. Wants to know yesterday what lawsuits they can file to bring Bruen to bear on their particular picadillo or their or the thing that or the thorn that's sticking in their craw. But I think you make a good point. We're still unraveling this. The other law professors I know are still parsing this opinion and mining it for the gold that's in there.
It's a long decision. I mean, it's actually easy to read. It's not like, okay, I can't understand the legalese. Anybody can get this and read it. Just sit down and, I don't know what it is, 130 pages or something. It's not a difficult read. But when you start going through it, you're going, wow, then holy cow, or, oh, that's great. It's like more and more. If you would, Don, just kind of give us a synopsis of what originally it was about, and then what we got as the gift in the middle of this thing.
Okay. Well, the challenge here is that New York had a law that said in order to carry a firearm outside of your home, you had to demonstrate a special need for self-protection that was distinguishable from the general community. So in other words, you had to have a particular danger, okay? You had to articulate a particular danger that was focused on you. But that was just cover for the government basically handing out permits to their friends and relatives and other politically connected people, and the rest of us being told that, no, your life's not as important as the rest of us. Mm-hmm. Now, of course, contrast that with 43 states having some form of shall issue regimen. And even here in Idaho, we have constitutional carry even for non-residents of the state. If you're a law-abiding person, you can carry a firearm in public to protect your life. Mm-hmm. But before, and what the court did is the court just said, look, there's no other constitutional right that you have to demonstrate a need for it. No, you don't have to say, well, I'm a particularly bad sinner, that's why I need to have access to a church, or I have something particularly important to say, and that's why I need the First Amendment, or my home is more sacrosanct than yours, therefore you can go search everybody else's house without a warrant, but you need a warrant for mine. So this idea that citizens of a republic have to demonstrate a special need to exercise a fundamental right is just foreign to the Constitution, and that's the nub of what this case, the results of this case.
Right.
Now,
the New York law, as it was, required you to be extraordinary. Ordinary people could not get the permit just because they wanted to be safe. You had to exhibit and prove to somebody that you had an extraordinary circumstance. And the court says, no. Rights are for everybody, not just for the extraordinary.
Yeah, which kind of leads me to a little point, a point of privilege I'd like to make, and that's this. Finally, the Supreme Court has caught up with my old mentor, Don Cates, who departed this earth in 2016. But he wrote the leading landmark article on the Second Amendment 40 years ago. It's called Handgun Prohibition and the Original Meaning of the Second Amendment. It appeared in the Michigan Law Review. You can point your search engine to Michigan Law Review and type in Cates and Second Amendment, and you should be able to find it.
Right. It was published in 1983. It came out.
That's right. Okay, so it's 40 years ago. 40 years. Well, it's 40 years, and now they're catching up to Don.
Okay, so and that leads me to a point I'd like you to jump on, which is this stuff takes a long time, and basically the terrain has been altered, but it had to be plowed for 40 years.
Yes, and this is why your listeners need to give a silent thanks to people like Don Cates and Don Kopel and Dave Hardy and Stephen Halbrook. These are the legal scholars.
And you, my friend, Don Kilmer, don't leave yourself out. You're one of them.
Well, I appreciate, but I appreciate that. But these men plowed the field. I come on the scene 20 years later because I'm younger than them, which is
there's that,
which I'm enjoying. But these men did laid the groundwork for us litigators to get in there and do some of these cases. But and also it's not just the legal thinking; it's providing the capital to litigate these cases. So Alan Gottlieb with Second Amendment Foundation and NRA Civil Rights Foundation and the other gun rights organizations that go out there and do the hard work of raising the money so they can provide those funds to lawyers like me to litigate these cases.
It takes hundreds of thousands and millions of dollars over the course of decades to get this. And the other part of it is that people get upset, particularly now in the age of instant gratification and instant outrage. They get upset when we either don't win something or we don't win it as big as they want, and they want it all right now, today, by noon today. By golly, I want it right now. And I want to go back and say, look, long view, it's a long game. 40 years been working on this. We've been changing the landscape. We've been getting these law review articles written, and it takes time and it takes work. And then those get cited by the Supreme Court in Heller and in McDonnell, 10 and 12 years ago, and now again in the Bruen decision. And none of this would have happened if it hadn't been for Cates and Gottlieb and Kilmer and all the rest of them that started 4 decades ago.
Yeah, and also, by the way, the legislative landscape that has changed. 30 or 40 years ago, there were literally only a handful of states that were shall issue. Today, we have 43 states or 44 states that are shall issue regimes or constitutional carry regimes, so that the right to carry in public, although as Bruen explains, is enshrined in the Second Amendment, also became this kind of organic bottom-up acceptance of the right that we got from our state legislators. There's 51 constitutions in this country that we look to for our rights. There's the one that was drafted and sitting in Washington D.C., but there's 50 other states that do these things. So the hard legislative work of getting reasonable, rational accessible constitutional carry and shall issue carry in these 44 states made New York and California and Maryland the outliers. Okay, so
exactly,
that's all important work too.
All right, Don, I'm going to get you to hold on here. We're talking with Don Kilmer. When we come back, we're going to reveal the other part of the surprise, the part that, as I say, I really dared not even hope for anything as good as what we got, and how, frankly, I think it may not be overstating it to say this changes everything when it comes to gun control laws in the country. We're talking with Don Kilmer. I'm Tom Gresham, and this is Gun Talk. All right, back with you. It's Tom Gresham. It's Gun Talk. It's an important week, maybe, I don't know, maybe the most important week. The decision that came out of the United States Supreme Court on Thursday, it's called the Bruen case, the New York State Rifle and Pistol Association versus Bruen, challenging New York State's scheme on issuing or not issuing concealed carry permits. Well, that went down hard, which is going to affect 6 or 7 other states. I'll have to take a look at that. But there was actually more to it than that. And we're talking with Don Kilmer, Second Amendment attorney, also a law school professor. And Don, it's like we're saying, yeah, this was great what they did with concealed carry. And I always, and we talked about this, I had said, if we could get to a place where we could have strict scrutiny and require the lower courts to use that when looking at Second Amendment, that would be great. We didn't get strict scrutiny, did we?
No, when last we spoke, I said to you that a decision on scrutiny or methodology would be the grand slam home run. Well, that is what we got, okay? First thing is that the Supreme Court took the lower courts to the woodshed and cited from its own earlier decisions in Keller and McDonald about how the circuit courts were supposed to adjudicate Second Amendment claims. And honestly, it must be kind of embarrassing for those judges who wrote some of these decisions that are in jeopardy now, assuming they're capable of being embarrassed, that the Supreme Court had to basically engage in a remedial class on how to read a Supreme Court opinion. I mean, Thomas goes he kind of says it over and over again. Look, we said this in Heller and McDonald, but Let me spell it out for you now in small words and pictures.
Yeah, it was like he was saying, okay, children, he said, children, let me explain this to you. You need to knock it off, what you've been doing there. We told you this was a real right, and then you've been saying, yeah, it's a real right, but, the government has its interest too, and when that overweighs the right, then we'll just do whatever the heck we want to do.
Yeah, I would just like to quote, because Thomas is he's such a great jurist, because he doesn't just write for judges and lawyers. He seems to be able to write for everybody. So, as you stated earlier, this opinion is absolutely accessible to anybody with good reading comprehension and a decent 12th grade education. But I'd like to just quote one portion here. Here's the judges. This is the new rule that the court has laid down. To determine whether a firearm regulation is consistent with the Second Amendment, Heller and McDonald pointed to 2 relevant metrics. First, whether the modern and historical regulation imposed a comparable burden on the right of armed self-defense, and second, whether the regulatory burden is comparably justified, because individual self-defense is the central component of the Second Amendment. These 2 metrics are central considerations when engaging in an inquiry. So that's the new standard. There's no more of this interest balancing and intermediate scrutiny and important government interest and substantial burden. All of that is out the window now for this basically one-step process. Does the regulation burden the right? Mm-hmm. And was there a comparable regulation in 1791 for a federal law and in 1868 for a state law?
This actually goes beyond and is higher even than strict scrutiny. He basically said if I read this correctly, there's virtually no scrutiny. It's basically, is it a right? The government doesn't have any balancing things against that.
Hello?
Yep. You still got us, Don?
Yeah, I'm still here.
Okay, yeah, I was just saying, it seems to me that this actually went beyond strict scrutiny. He kind of wiped the whole balancing and the scrutiny levels off the table.
Well, the tiered scrutiny, and by the way, you can find law reviews articles out there that say that there are 5 levels of scrutiny, okay? Traditionally, people are taught in their civics class that there are 3. But there's absolutely no constitutional or textual justification for this. The most dangerous form of scrutiny is the one that kept being applied to the Second Amendment. That's intermediate, and that's where a judge basically gets to start engaging in kind of blank canvas balancing of, well, is this an important government interest, and is this is this regulation going to address the interest? And judges aren't supposed to do that. That's what legislators do.
Right.
And the icing on the cake is that Thomas even kind of anticipates and calls out as unconstitutional the gamesmanship that he anticipates. Just a short list that I worked up for our show. He basically said, look, the term arms does not apply only to 18th century guns. So that's out the window. Okay. The entire island of Manhattan cannot be declared a sensitive place. So that's out the window. Okay. Any historical evidence of a regulation that either long predates or postdates the founding or ratification of the 14th Amendment doesn't tell us anything. So citing the Statute of Northampton from England doesn't help us. Okay. And then early American restrictions on arms carrying have to look at both concealed and open carry regulations. There's an old Hebrew proverb that says half truth is a whole lie. The government keeps trying to cite these laws in certain jurisdictions that ban concealed carry, but they never finish the statement. They banned concealed carry, but they left in place open carry. Mm-hmm. Okay, and Thomas goes into a very long dissertation on that. That the issue is bare. Obviously, what that leaves in place is carry regulations are going to be different in rural Idaho, okay, than they are going to be in Manhattan. In fact, in Manhattan, you could make the argument that concealed carry is preferable because you don't want people walking around with guns openly carried.
But what he did say is the states have to allow some sort of carry, open or concealed. They can't just block it off, and they can't just say no to any type of carry, can they?
Yeah, no, they can't. And what's interesting is that when you actually do the research, getting back to this, half truth is a whole lie. The reason concealed carry was sometimes regulated, and it wasn't universal by any stretch. It wasn't even in the majority of jurisdictions, but in some jurisdictions, it was because people thought back in the late 18th century and early 19th century that only thieves and assassins carried concealed. Everybody carried open. Uh-huh. Okay, so that's the point: is that bare means carry, and carry means some form of either open or concealed carry. I mean, there's only two ways you can do it. And then he ends it with the constitutional right to bear arms in public for self-defense is not a second-class right. Okay? The exercise of constitutional rights does not require individuals to demonstrate to government officers some special need. So we got two things out of Bruen. We got a roadmap for adjudicating future cases, and we got this May issue or discretionary issue struck down.
Okay, and I'm gonna. This is such an extraordinary ruling and such an extraordinary thing to happen to us. I am of the opinion, and I'm not the legal scholar here, but I'm of the opinion this very well may be the most important thing that's happened to the Second Amendment since it was originally written. Don't know if you'd agree with that, but I think, and here's the thing I want to throw out to you, and I'm going to hold you over the break. We just have to. It's too good for this. Does Bruen give us the possibility of just simply overturning a whole bunch of gun control laws that are in existence now?
There's fertile. These state and local regulations are now we're in a target-rich environment again. There's definitely some. For example, one of the post-Bruen, the Second Amendment means that common and ordinary guns that an individual can keep and bear are protected by the Second Amendment. You can have them in your home and subject to some kind of shall issue regime. And I'm thinking,
Don, hold that thought right there. I want to tease this thing going into this. I think what he's about to say is so-called assault weapon bans are off the table, not available, unconstitutional. We'll continue with this when we come back. Did all you want to do is talk about guns and ammo? What's the newest thing, or talk about an old gun? All this talk about a Second Amendment and a court case may seem like, what's the big deal? Well, this is the biggest of the big deals. Welcome back. I'm Tom Gresham. It's Gun Talk. We're talking about the Supreme Court decision that was handed down Thursday morning. It's called the Bruen case, ostensibly about the New York State scheme on issuing concealed carry permits. That was struck down. I said you can't require somebody to have to show proper cause. Other states require similar things or have similar systems. Already, California and I think New Jersey have already issued, the attorney generals there have already issued opinions to sheriffs, DAs, et cetera, saying this law that we're operating under will not stand. It's now unconstitutional, so get ready to get rid of that proper cause thing. We're talking with Don Kilmer. He's an attorney, a Second Amendment specialist, a law professor. And Don, one of the things I want to ask you is on the basis of Bruen and this other part where brilliant Clarence Thomas gets rid of the two-part system, two-step system of, it's a law, but, have to balance that against social or community or government interest. What could we think could be done with that in terms of what kind of laws? I mean, I think you were headed toward the idea of banning certain kinds of guns. You might just get us started on that.
One set of laws that may be particularly vulnerable, is this term, this loaded political term, assault weapon, is first of all, it becomes a distinction without a difference at this point, because the inquiry now is it an arm? Yes. Okay. I mean, that's obvious.
Right.
Is it useful for self-defense? If it's useful for self-defense, was there a regular government regulation in 1791 or 1868 that allowed efficient, rapidly reloading or easily usable firearms for self-defense to be banned? If the answer is no, that ends the inquiry. The law is unconstitutional.
Okay, so semi-automatic firearms, can't ban those. That would be unconstitutional. But there also was no law in 1868, which we're talking about the 14th Amendment, right, on that one?
Yeah.
Okay, there was no law then that said we would ban full automatic guns or short-barreled rifles or shotguns. So what happens to the National Firearms Act, NFA?
Well, that's a mixed question.
Okay.
One of the things the court left in place with Bruen is that common and ordinary firearms are protected, but uncommon and particularly dangerous weapons can still be theoretically regulated.
Okay.
I don't know what side of the line machine guns would fall on, but I certainly know that short-barreled shotguns, are very useful for home defense and self-defense. Mm-hmm. No reason why those should stay on the NFA list. No reason that suppressors should be illegal or regulated in any specific manner.
Right.
Suppressors are not even weapons. I mean, they're basically a firearm accessory.
Right.
So there's certainly a target-rich environment for taking a look at a lot of regulations at the state and federal level where analogous regulations in 1791 and 1868 just plain didn't exist.
How about standard capacity magazines? 15 up to 30 round magazines and more.
That's again, the term magazine actually has quite a long history in the history of firearms and firearm accoutrements. But no, when you showed up for muster in the militia, you were required to show up with 20 rounds. Okay, so I don't know that there is an upper limit at this particular point in time. Again, the inquiry is this: is this item useful for self-defense? If it is, was there a historical analog that regulated this item? If the answer is no to both of those, or if the answer is yes to the first one, yes, mm-hmm. It's useful for self-defense, And the answer is no to the second question. No, there's no analogous historical regulation that ends the inquiry. The government's regulation is presumptively unconstitutional.
Because Justice Thomas said that self-defense, personal self-defense, is the core concept in the Second Amendment.
Correct. So one person who's facing 20 or 30 rioters coming down their street, well, and you can see behind them they've left a trail of burning houses or smashed windows or injured people. What are you going to want to walk out your front door with? A single shot deer rifle or your AR-15 with a 30-round mag?
Right. No, exactly. So what I think I hear you saying, and look, this is going to be a full employment act for attorneys, and we're going to have years and years of litigation. But I'm seeing immediate challenges to all the so-called assault weapons bans, to magazine capacity limits, maybe to some aspects of NFA. Could we even conceive of challenging some parts of Gun Control Act of 1968?
Well, there are probably some isolated parts of GCA 68 that are vulnerable, but I think that the regulatory scheme for preventing felons and incompetent people, mentally incompetent people, or mentally ill people from getting guns is probably going to remain part of the federal regime. Yeah.
Well, I could dream.
Then invite me into your dream. But
what else do you think of when you just kind of brainstorm? What else could happen on the basis of this?
Well, what's interesting is you'd sent me right before the show started. You'd sent me the memo by the California Attorney General that he issued, telling sheriffs how to apply this law now. Now in California, it's a state law and it's also a statewide permit, but it's sheriffs and chiefs of police who issue the concealed carry permits in California. So the AG then sends this memo to sheriffs and chiefs of police and says, okay, well, you can no longer require good cause, but you can require good moral character. And here's this is disingenuous to the extreme. The California AG says that, legal judgments of good moral character can include, I'm quoting from the memo, considerations of honesty, trustworthiness, diligence, reliability, respect for the law, integrity, candor, discretion, and observance of fiduciary duty, respect for rights of others, absence of hatred and racism, fiscal stability, and professional specific criteria, such as pledging to honor the Constitution, uphold the law. Well, he's just disqualified 4/5 of all the legislators sitting in the United States.
Well, so having to exhibit good moral character, I think that would be challengeable right off the bat.
Oh, yeah. I mean, it literally, good moral character is going to have to mean, look, are you a law-abiding citizen? Okay. Are you currently subject to an order of protection or something because, you're a wife beater or something and your wife or your girlfriend got a restraining order against you?
Basically,
okay. Now, and by that, I mean a fully adjudicated restraining order where there's been a hearing and evidence and somebody's made the call that, yeah, you're a dangerous guy. Now that could be grounds for saying, no, you can't have a concealed carry permit. Of course, that already disqualifies you from having a gun at all.
True. Oh, what about red flag laws that do not have a provision for due process? Under the 14th Amendment, you're supposed to have due process.
Vulnerable. Red flag laws, there's absolutely no historical evidence for red flag laws.
Wow. Okay, hold on a second. I got to take a quick break. I'm way over. Hold on a second, Don. Jim's telling me, take a break, man. You're all wound up here. I'm all wound up. I can't help it. This is huge. I mean, it's like, okay. And oh, by the way, this would not have happened without Donald Trump. Like him, hate him, 3 justices on the Supreme Court. This would not have happened without Donald Trump. I may not like him as a personal guy. I don't think I would like to spend time with him. But what he did there was huge. We'll be right back. Okay, so why am I jumping up and down about this Bruen decision that came out of SCOTUS? Well, let's see. Could be the end of the so-called bans on so-called assault weapons. Could be the end of bans on standard capacity magazines. Red flag laws that do not have due process built into them could go away. Of course, it gets rid of the show proper cause and probably show good moral character before you are issued a concealed carry permit. All the states become shall issue. And to those in Hawaii, I would just like to say aloha to freedom. I'm talking with Don Kilmer. And Don, I mean, I am just about coming out of my skin with all the possibilities. And this thing broke at like 10 o'clock Eastern time Thursday. And before the day was out, there were already filings in courtrooms around the country based on this.
Yeah. Keep an eye on some of those. I was given a task sheet by Mr. Gottlieb at the Second Amendment Foundation, and I've got a couple of teleconferences scheduled with some other lawyers and law firms around the country for next week.
So you're going to be a busy guy.
Yeah, apparently I'm going to have to put off retirement.
Yeah, but you know what? This is for a good cause, isn't it?
I'm really just halfway teasing. I don't ever intend to retire. I'm having too much fun.
You know, it was kind of one of those deals of, I've been fighting this for 50 years. You've been fighting it for decades. It doesn't go away, and the forces that want to ban your guns never go away. And you kind of have to take the long view on some of this. And sometimes I get a little bit frustrated with our folks who just say, we've got to have it all right now. And if you're not willing to go for everything now, if you're willing to only take some of it, then somehow you're less than what you should be. And that's frustrating.
Yeah. You know, what's interesting is that there actually is a link between, and if I get into dangerous territory, feel free to cut me off, but there is actually a link between the Bruen decision that was issued on Thursday and the Dobbs decision on abortion that was issued on Friday. And I'm not going to get into abortion politics at all. Okay. But look at the difference between how the gun rights community chose to protect the Second Amendment. They worked in the legislators. They tried to get law review articles published. They worked incrementally to advance, shall issue carry at the state level. And today we have a result of Bruen saying, look, this is obvious, folks. This is what the Second Amendment means. It is an important right. In 1973, Roe versus Wade sucked all of the oxygen out of the abortion debate. And it was basically, it's been a dead issue for 50 years, or everyone tries to pretend it's been a dead issue for 50 years. Even Ruth Bader Ginsburg, who was obviously, pro-abortion rights, she's even criticized the decision of saying, at the time this Roe was decided, states were developing their own contours and their own permutations on what the right should be. This idea that we have even from Supreme Court precedents of the 50 laboratories of democracy that we have in our republic at the state level. And so what happened is it cut off. And now that the Supreme Court has abrogated the holding in Roe, the people, whatever side of the issue you're going to go on, you're going to have to go fight this at the state legislature level.
So what you're saying is
that's how the fight has to happen.
Yeah, they gave up 50 years of being able to work on this the way we've been working on it.
Exactly. The gun rights community did it the democratic republic way, and then says, look, we need to keep working on this. We need to advance incremental changes. So when we get to Bruen in 2022, we look back on it, guys like you and I who are a little long in the tooth say, yeah, we've been saying this for 50 or 60 years. Mm-hmm. The abortion debate, unfortunately, what Roe did is it said there's no debate. It's a constitutional right.
Hey Don, I'm gonna have to roll, man. I gotta go. Not only can we do this, we do this at great length. Thank you so much, Don Kilmer, attorney, law school professor. We appreciate what you do, and we'll bring you back when we get a little bit more unpacking done on this. I sure appreciate it, sir. And I hate to cut you off, but we just have to do that. Our number is 866-TALK-GUN. Just how happy are you about this?